Okay, well, welcome. Thank you for joining us on this warm summer day. I'm Kate Kilberg. I'm one of the partners at Catalyst Law. And this is Kimberly, also another partner at Catalyst Law. And we're excited to talk with you today about just sort of basic estate planning, and then also with a clinic for we're going to go through something called a power of attorney for a minor child, which will be useful when you have an occasion to leave your child with another caregiver, even if it's just temporarily. So can we go ahead and put the slides up?
Yes. Oh, I'm working on it. Sorry.
Okay, no worries. Technical difficulties. Thanks.
Here we go.
And also, I'll just say here in the beginning that we're going to continue to kind of just roll through the slides and the material. But if you have questions, if you go over in the chat box, you can feel free to go ahead and just type a message in the chat box, and we'll see it and we'll do our best to answer questions sort of as they come up. Or if not, then certainly by the end of the presentation, hopefully we'll get all questions answered. And I'm going to type over there right now. So you should see what I'm talking about. Okay. Okay. So, and I think, oh, you know what? I sent it to the wrong, let me try again. Okay, so do we have the slides up yet?
Working on it.
Okay. Molly, well, Molly, you don't have them, do you? Let me see if I can figure out how to put them up.
Yeah, if you email them, I can do it.
Sorry, I can do it here. I think this will work. Did that work?
Yep.
And is the slideshow started, or did it show? There we go. Does it look okay? I can't see it.
Looks good.
Okay. So so Kimberly, do you want to get us started with the beginning of the presentation?
Yes. I do. Okay. So in this presentation, we're going to talk about just kind of some trends that we see with people and their mindset around estate planning. And we're going to actually ask you some questions about where you are in your own mindset with respect to your estate planning, and then talk to you about kind of the general public and why so many people in this country do not have estate plans in place. We're going to walk through the basics of a good estate plan and how Catalyst works, so our process. And then, and in the basics of the estate plan, we're going to talk about the temporary guardianship agreement. And we will provide a form for you when we get to that point in the presentation and go over the form with you. So, Kate, do you want to kick it off?
Are you still seeing my slides?
Yes.
Okay, sure. So what we want to talk about is just for all of you online to think about whether or not you need a will, and go ahead and put in the chat box if you would. How many of you believe everyone needs a will? And if you'll type in the chat box if you do believe that, that would be great. And how many of you want to make your death as easy on your families as possible? Go ahead and type in the chat box. How many have talked to a friend or a family member about estate planning? And how many have talked to a financial advisor, a lawyer, or an accountant about estate planning? Well, you may be interested to know there was a poll done in 2019, specifically trying to figure out why folks don't have estate planning. I'm going to switch the slide. Did that work?
Yeah, we're seeing the whole
Yeah, that's what I was worried about.
whole thing.
Okay, is that better?
That's the presenter's view.
Oh, gosh. We are really having trouble today, guys. I'm not sure how to switch my screen. So let's try this. How's that?
Great.
Okay, so from the 2019 caring.com poll, 76% of people believe having a will is important. 90% wanted to make their deaths as easy as possible on their families. 50% have talked to somebody about doing an estate plan, but only 40% actually have an estate plan. So the next, so one of the things as estate planners that we think about is, well, why is this? And so Kimberly's going to talk a little bit about what we think about why folks don't have estate plan.
So in many situations, a lot of folks don't know much about estate planning, or they think it takes too much time. And some think that they don't have anyone to leave assets to, that it might be too expensive, or they don't know how. This is about 5% on each of those reasons. Almost 22% of people say they don't have assets to leave to anyone. And 50.4% said that they just haven't gotten around to it. And so that type of lack of long-term thinking is really the leading cause of why someone does not have the estate plan. So if you look at the pictures on your screen, you know, we are a culture of immediate gratification. We will, you know, we want the fast food. We don't really like to floss, although we know it's good for us. You know, we want that big screen TV instead of putting the money in our savings account. And in general, we think about the short term and not the long term in our culture. And the reality with, you know, these reasons is that oftentimes people don't say that they don't have enough money to be concerned about estate planning. And in reality, everyone needs to be thinking about it. So for parents with young children, it's very important for you to have a will to clarify who will care for your children if you die while they are minors. And it allows you to provide rules, and just like you provide boundaries for your children when you're raising them, an estate plan provides your children with boundaries about how they would use the money and the property that you leave to them, and how that's going to be administered. So if you don't specify who the guardian of your children would be, the court actually decides that for you. This can create a lot of problems, particularly if you'd rather have a friend serve than a member of your own family. Typically, family members are given priority. And the court battles along these lines can be quite painful for everyone involved. So if you do have minor children and you have some problems within your family, you don't want your children, you know, necessarily going to grandparents or siblings, this is a really good way to make sure that that would not happen in the event of your death. And then the other issue that we see come up again and again is that if a minor inherits property outright, it becomes subject to a guardianship, and conservatorship. So the guardianship would be court supervised, and a conservatorship as well. So without a will or without a trust, the assets for the minor are kind of held in trust by the court and this conservator until the child turns 18, upon which time the child can spend the money as they want to when they become an adult. So there's no way to prevent use of funds, if the child decides to spend it all on a Lamborghini. And the legal guardianship and conservatorship also just imposes some really rigid rules around how you can spend the money when the child is a minor. So just from the point of view of needing to provide for minor children, even if you don't have much in the way of assets, you do want to make sure that you have a guardianship provision in place and in a will. And this is the guardianship provision if you die, and we'll talk later about the guardianship provision that you might want to have in place temporarily. So those are two separate documents. Now, many people don't want to contemplate their own death. Most people say, if I die, but really it's a matter of when I die, because that happens to all of us. And whether or not you plan for it or you leave everything up to chance, your estate will be left to someone to sort out. So if you don't put a plan in place, the state decides what will happen with your assets, where your minor children will go to live and who takes care of them. And likely this is not necessarily what you intended. Although you didn't intend to die, that's going to happen at some point in time. And you want to make sure that your wishes are followed if that does happen unexpectedly when you're not prepared. And then the third bad reason is that a lot of people say, I don't have enough time or enough money to hire a lawyer to do my estate planning. And estate planning is really important. It should be part of any well thought out financial plan. Those of you who go to financial planners are, taking the proactive steps to raise money or to save your money. But without a estate plan, the financial planning doesn't necessarily last for the long term if you do pass away. So at this point, Kate is going to go through how Catalyst actually does estate planning, our process, give you an idea of costs, and then we'll just get into the details about what is in an estate plan and talk more about that temporary guardianship agreement. Kate?
I'm coming, just sorry, I'm getting back on camera. Okay, so as many of you know, at Catalyst, we've really done all we can to make the estate planning process as easy and customer friendly as we can. And so what we've done is broken down the process into a series of 3 meetings, and we do everything on a fixed fee basis. Over 20 years of experience with estate planning, I've learned a lot of the pain points that can happen with the estate planning process, and so we've tried to smooth out a lot of those rough spots. The first being that we do everything with a fixed fee. So our fixed fees for basic estate plans at Catalyst range from $3,500 to $4,800, and we take those in a series of 3 payments. And we do 1 payment at each of 3 meetings. So the first meeting is we get to know you and your family and your assets. We'll give you some education about what is probate and whether we think it might be important for you to avoid it or not, and whether we think a will plan or a trust plan is right for you. Before I kind of go on there, I do want to say on the slides, we also have an affiliated nonprofit the Commons Law Center that also does a very similar estate planning process. So what I'm talking about applies both to Catalyst and to the Commons Law Center. And if those price points that I mentioned earlier feel like a stretch for you, you're certainly welcome to use either Catalyst or the Commons. The Commons provides similar services, like I said, but on a sliding scale basis based on income levels. So again, just to talk through the process, it's 3 meetings. The first meeting is where we get to know each other. We get a little bit more information about you. We give you some education about the process and what we recommend. And then we go away and we go to our offices and we draft estate planning documents for you. And then we send them to you for review. So again, after practicing for 20 years, one thing that I've realized is that people don't really enjoy reading legal documents in their spare time. So what we've decided to do is we have everyone come back for a second meeting once you've had a chance to review the drafts, and we go through the drafts together. So the lawyer in that meeting will go through with you and will explain to you and point out the important provisions of the documents. And you'll have a chance to ask any questions or tell us about any adjustments that you would like us to make. So maybe we spelled somebody's name wrong, or you told us something specific that you wanted that we didn't quite get right. So that second meeting is a chance for us to come back together. Again, just make sure that we got it right, that we accurately reflected your wishes. And then we go away again. And you give us a little bit of time to make those changes if there are any that need to be made. And then we come back together for a third meeting. At the third meeting is when you sign all of your documents. Pre-pandemic, you would walk away with a binder full of all of your original estate planning documents. And our process is designed to be very comprehensive. So I'm going to speak a little bit about what we're doing now during the pandemic. And then I'll also sort of go through, and I'm going to go through in a minute about what all is included in that comprehensive estate plan. So because of the pandemic and the social distancing, we have a few options. So we are doing in-office signings if folks feel comfortable with it. So we have set up a system where everybody wears masks and has gloves, and we give you a pen that you take with you, and we do it through a glass wall in our office, so we can watch and see and watch you and witness you sign things, but we're making sure to keep everyone as safe as we possibly can. So that's one option if you are comfortable with it. If a client is not comfortable with an in-person signing, we certainly understand that as well. And what we can do is we can send you all of the documents with instructions for you to execute them on your own. And along with those documents will be a special declaration that says, basically, I'm doing this during a global pandemic, and for that reason, in-person meetings are extremely dangerous. And it's my intention that the documents that I'm signing serve as my will or revocable trust, even though I'm not doing them, according to the precise procedure that is laid out in the Oregon statutes. And there is a statute that we're relying on there that says that if you have that type of evidence, that a document is intended to be somebody's will, but it's not properly executed, then it will be effective. So we're using that as sort of a stopgap during this period when we have a number of clients who just are not, they're in a compromised health situation, or they're elderly, they're just not comfortable coming into the office for a signing. We use that as our stopgap measure. And whenever we get back to normal and it's safer to get together with folks, we'll have them come and redo the signing, following all the formalities as necessary, so that they're in compliance with the statutes. That's required. It's pretty clear that we can't witness estate planning document signings on Zoom or other video chats. So that's the process that we've that we've devised, and of course we're happy to work with our clients to make sure that everyone feels safe and that we get done what we need to get done. I think that's it for me. We're going to go into. Did I skip anything, Kimberly?
Nope. We do follow up with everyone every 2 years. Not sure if you mentioned that. Just trying to get some slides over to Molly. And so part of our ethos in serving as your estate planning attorney is to make sure that you understand everything that you're signing, and that we give you the opportunity to follow up as life circumstances change. And we want to make sure from time to time that you are, as you progress throughout your life and things happen, that we're making sure to update those documents, either, when something happens in your own life or when the tax code does change, which it does from time to time. And as it did very recently. So, why should you join about 40% of fellow Americans who have an estate plan? And we're going to go through the top 4 reasons. So the first reason is to save taxes. So for example, if you have a life insurance policy of $1 million and you were to die, and you also have a house and you have some retirement money, so let's say you have another $1 million in assets there, then you are taxed at the state level, and not at this level, but the federal tax also has a state tax. They call it sometimes the death tax. But these taxes are a one-time transfer tax. And so anything over $1 million in Oregon is taxed at 10 to 16%. Currently, the exemption at the federal level is more than $11 million per individual. So not many folks in Oregon have to worry about federal tax at the moment. But that level will be coming down to $5 million again in 2025 unless we see additional changes to the tax code. So given that you're an Oregon resident and you have $2 million and $1 million is coming from a life insurance policy, if you put $1 million, the $1 million life insurance asset into an irrevocable life insurance trust, it can save at least $10,000 in estate taxes because it's going to take that life insurance policy out of your estate for tax reasons. So there are techniques such as the irrevocable life insurance trust that can help you save on taxes and make sure that that money, instead of that money is going to your children or to the causes that you care about, unless you want to donate it to the state of Oregon, in which case that's also something that people can do. The second reason that you want to think about putting an estate plan in place is to avoid probate. So probate is relatively expensive. The process takes quite some time, particularly now with the pandemic. Courts are operating at a much slower rate. There's backups throughout the court system, and the more time that we are not operating with the full court activity from previously, the longer it's going to take for courts to get through the extreme backlog that's being created right now. And prior to the pandemic, things weren't exceedingly quick with respect to the courts either. So, the other reason is that, saving money in the long run, you want to have really clear documents. You want to make sure that you have, a professionally prepared estate plan, because unclear documents are expensive. They oftentimes require expensive settlement agreements that have to go through the courts, court proceedings. If something is not clear, people do get into arguments about what it might mean. And those processes are also very time consuming and can get expensive. So an example that Kate usually uses when talking about this is that in 2010, when she was administering 2 different estates, under $1 million, so relatively modest for Washington, D.C., where she was practicing at the time. The well-planned estate legal fees were approximately $9,000 because everything was very clear. It was clearly laid out, very well organized. For administering a similar estate, similarly situated situation, again, under $1 million, under $1 million in assets, but with poor planning, the total fees for that administration amounted to $45,000. So if you do invest some time and money now, it actually saves time and money for your beneficiaries and your heirs when you do pass. So we really encourage you to think about kind of, I think that your organization then leads to other folks, you know, being able to live their lives and not be consumed with an estate administration for months and months. The third reason that it's really important to have a plan in place is to prevent family disputes. So, you know, like I said, because, you know, if you have unclear documents or if you have a rift in the family where, let's say, your children don't get along, it's really important to have something in place and something that's clear. And we often recommend that you speak with your beneficiaries about your plan prior to your death when you've prepared your estate plan, so that there are no surprises. You know, it's definitely a personal choice in how much you talk about money and you talk about death in your family. But we've definitely noticed, and it's kind of common that the more that that you talk about the plan, the more that people are going to be accepting of that plan upon your death, particularly if it's an unexpected passing. And then really the estate plan is a way to express your values. So like all of your financial decisions, you know, the way that you leave your assets at death should be aligned with your values. And a catalyst that's really important to a lot of our clients, you know, our values would be, you know, family and community, and making any charitable gifts, any legacy type gifts. You know, it's really important that you plan that out in advance. So now that we've kind of talked about the reasons why you should put an estate plan in place, I'm going to turn it back over to Kate, who's going to talk about just the basics of what's included in what we call the just the basic estate plan. So everyone should have these documents that she's going to talk about now.
And so I'm going to, there's supposed to be, let's see. So the first piece of any good estate plan is going to be the revocable trust or the will. And so I'm guessing that most of us know what a will is, but just in case, will is just a document that anyone can put together that says what they want to happen to their assets upon their death. And so it generally talks about what should go to friends, what should go to family. In the normal course, if you do a will, if you still own all of your assets in your sole name and you do the will, your assets will need to go through a court process called probate in order to pass to your beneficiaries. So one technique for avoiding probate is that a lot of people will actually use a revocable trust instead of a will. You can just think of a revocable trust as a substitute for a will. Essentially, another way to think about a revocable trust is it's just a box. And so essentially what you do is you put your assets into your revocable trust box during your life. And then the trust document is instructions from you to the trustee about what they should do with the assets in the box. And while you are living and competent, you are the trustee. So you still retain all control over the assets in the box. You can use them how you want, you can sell them, you can give them away. It's solely to avoid probate. So the revocable trust, again, doesn't change anything for tax purposes. Its only purpose is to avoid probate. But it will also contain your wishes about what you want to have happen with your assets, and what should happen and how you want your family, particularly a minor child. The will also have a discussion about who you would like to have nominate as the guardian for any minor children. The second basic document for a basic estate plan is a durable power of attorney. So the revocable trust and the will, those documents are both planning for the event of death. The durable power of attorney and the advance directive, which I'm going to talk about in a minute, are both planning for the event of disability or incapacity. So the durable power of attorney is where you are naming somebody who can do things like pay your taxes, file your tax returns, pay your bills, get your mail, and basically manage all of your financial and property matters in the event that you're not able to for some reason. And they can be either effective immediately, right when you sign it, so you can turn that power over to somebody right away, or we can do what's called a springing power, which means that that document doesn't become active until you are certified to be disabled by a physician who's examined you. The next document, as I mentioned, is an advance directive. So the advance directive is also planning for the event of disability or incapacity. And this is the document where you state your wishes about whether you want life-sustaining treatment in various circumstances. This document is prescribed by the state of Oregon. So it's a form that the state of Oregon requires for Oregon residents in order to put together their advance directive wishes. And it also has a section where you can name someone who will make those decisions for you if you're not able to make them for yourself. A HIPAA waiver. So it would be challenging for your healthcare representative to make healthcare decisions for you if the doctors weren't allowed to share your healthcare information with them. So along with the advance directive, we also do a separate HIPAA waiver document, which specifically allows your doctors and healthcare providers to share information with your named representative in the advance directive. We'll also look at life insurance, and so different folks in different situations, we might recommend that you look at getting a life insurance policy if you don't already have one. We'll also look at whether, if you do have life insurance, if it makes sense to create something that Kimberly referenced earlier called an irrevocable life insurance trust. So any good basic estate plan should be looking at your life insurance and deciding if you need more, if you need less, should we be putting it in a trust or should we leave it the way it is? We'll also look at your beneficiary designations. So most assets, as I talked about earlier, to avoid probate, you can simply put them in your revocable trust box. And now because you don't technically own them anymore, they avoid probate. There are some assets, however, that don't go in your revocable trust box. You can't transfer them during your life. Instead, you continue to own them and they pass by beneficiary at your death. So some common, probably the most common example of this would be a retirement benefit. So an IRA, 401k, 403b type account. Those will remain in your name until your death, but then they pass according to the beneficiary designations. And as we go through time, more and more folks have a lot of their wealth in these types of retirement accounts. And so one thing that's really important is to look at what happens under those beneficiary designations and to coordinate them with what's going on in the rest of your estate plan, the revocable trust and the will. And then finally, we look at form of ownership. So a lot of times there can be issues related to, so if it's a married couple, does the husband own the asset, or does the wife own the asset, or do they own it jointly? So the story that I like to tell about this, Kimberly was telling my Washington, D.C. estate story. I'm going to tell her story about the client who they were not married, I believe, and they owned a house, and they lived in a house together, and they owned it not as joint tenants. They owned it as something called tenants in common. And when the male partner unexpectedly died, his half of the house went to his son. This is the house where Kimberly's client lived. And so now she owned her house where she lived with her former partner's son, her deceased partner's son. And if I'm remembering the story correct, the son was nowhere to be found and had some drug issues. And so now she had been in a situation where she owned her house with someone she couldn't find and was troubled. So that's not a great situation. And that's something that if they had done some estate planning, the lawyer should have caught that and had them title their house in a different way to avoid that strange result. Okay, we're going to talk about a few special situations now. And one of those is if you have a minor child.
Yeah, so in the case of having minor children, there's some special considerations that you want to take to provide for them in the event of your incapacity or your death. The first is naming a guardian. The biggest benefit for having a will when you're a parent of a minor child is that you can determine who's going to raise your children if you and your spouse don't survive. If you're in an accident, if you are out with them and both of you pass away. And if there's no will appointing a guardian, then as I mentioned previously, the court will appoint one. And the benefit of maintaining control over this guardian appointment is that you want to make sure that whomever is appointed is familiar with your values, your lifestyle, your child rearing philosophies, and make sure that that person who's going to raise your child is as aligned as possible with how you would have done so. And so a lot of times naming a guardian can prevent conflict among family members because your wishes were written down and you're speaking through this document. And also having thought that out well in advance, it can really ease your child's transition into the new life at a difficult time because there's no confusion about who's going to take care of that child. That doesn't mean that grandparents and other family members couldn't visit if you appointed your guardian to be a family friend, but really that they would be raising them as a parent and working with all of your family members to make that transition as easy as possible. Now, in the case that you travel a lot, that you are going into the hospital, that you're leaving your child with someone to live with for a while, maybe you need to go somewhere for 3 months for some personal wellness or a medical condition. Any of these circumstances, when someone else is taking care of your child and it's not your spouse, you may want to think about naming a temporary guardian. So temporary guardian will care for your child, will be able to consent to medical care, enroll your child in school, or handle other parental tasks. And if your child needs emergency medical care and you're unavailable, it could be a real problem locating you for your consent. So there is a case that, or a story, and in one situation, the husband was traveling for work and in Europe, and the wife was at the gym and in her 40s suffered a fatal heart attack and died. And their 3 children were at their home with a babysitter. And the babysitter got very worried and contacted the authorities when the mother of the children didn't come home. And the authorities asked if she had, if she had the authority to take care of the children. And she said no. I mean, she had her own life, needed to get back to it. And so those children went into foster care until their father could return home. And so in that situation, that could be very traumatic for your children, not knowing where their mom is, not having any family members available. And, while that's kind of the best that the people, protecting public safety can do, it's best if that's taken care of in advance. And so in Oregon, as a parent or a guardian of a minor child, you can sign this power of attorney to give someone else the right to act as a parent to the child temporarily. And it's referred as delegating your rights and powers as a parent. So keep in mind, you can get your child back whenever you want, but be sure that you know and trust the person who's caring for your child, and be sure that that person understands that he or she must return your child whenever you want your child back, because it's only temporary. The temporary guardianship is valid for only 6 months. You can make sure that it's valid for less than 6 months. You can specifically state the date where it becomes invalid. And none of this requires going to court. So to give the temporary guardianship rights to another person, you fill out and sign a temporary power of attorney. And Molly's going to share that document with you now, and we can all kind of go through the form together. And that's something that you can take with you to, if it's something you're interested in doing. It can be a do-it-yourself, or you can seek help with completing it through our office. So you want to make sure that, you have some blank forms, because this is, so Kate's putting it on the screen here. And so what you're going to do is fill out your name. I, Kimberly Prey, the parent, hereby temporarily appoint Kate Kilberg, the temporary guardian, to serve as in my place and exercise all powers. So you're going to put your own identifying information, the identification information for your child, the identifying information for your temporary guardian. If you have more than one child, then you would create the form to apply to multiple children, or you could have one form for each child if they were staying with different temporary guardians. And then the second page of the power of attorney really goes into the custody and what decisions that the temporary guardian can make, and then the medical authorization and consent to treat. So this is one of the more important parts about this agreement, because typically only the legal guardian can consent for a child to receive medical treatment. Then it also provides you with this place to include your child's primary care physician, copy of the health insurance card, any travel authorization that's needed for that temporary guardian to travel. Maybe they're meeting you in Hawaii after you had a wonderful week-long vacation with your spouse. So this form will be available, and we can, and there's more, and general provisions. So you're going to initial at the bottom there of page 3, you're going to initial where whether it is a 6-month temporary guardianship, or if it has a date at which time it becomes invalid. The document needs to be witnessed and by 2 individuals and notarized. And so this is one document that you could get notarized through the newer electronic notarization services. that are now becoming a lot more popular, and they're now legal in Oregon. So you can get a notarization electronically. So are there any questions about the temporary guardianship agreement? It seems like, let's see. I'm not seeing any questions. Okay, I do have a question. So if I do pass away early and I'm currently divorced, would my ex-husband just receive full custody and that's the end of contact with my family, like my sister or grandparents? So in this situation, you can leave instructions in your document that indicates whom you would prefer to for the children to remain in contact with. There's also, I think in this situation, you might need to contact and work with a family law attorney because there are situations and there's ways in which you can establish that those third parties, like a grandparent, can remain in your child's life, and that, you know, an ex-spouse would need to work with your family members to make sure that they remain in contact. That's not handled under the guardianship provisions, but in a couple of circumstances in which the ex has not been involved in raising the children, the person that is writing the will will prepare a letter that goes with the will that explains the reasons that you would prefer someone else take over guardianship, and then that former spouse can, if they so wish, if they are not involved and don't want to be involved in raising that child, could then acquiesce and turn guardianship over to the person that you prefer. Kate, do you want to say anything else about that particular situation? Okay.
No, I think you've done a great job of covering it.
Okay, so you're welcome for answering the question. All right, so next we're going to talk more about some other special situations.
Molly, are you able to, do you have the slides now? So we're going back to slide number 12.
I don't have the slides.
Okay, I'm going to share my screen again, and we'll talk about slide number 12. So bear with me here. Obviously, the tech is not my strong suit. Oh, and I went too far. Let me catch us up. Actually, I'm going to spare all of you that and go here. Okay, now can you see my slide? Can you see my screen?
No.
Oh, good. It says it won't start. Screen sharing has failed to start.
Let me try and share mine. Hold on.
Okay.
You can start talking because.
Did mine work?
Yeah.
Okay.
Oh, there we go.
Okay.
Mom, do the rescue.
Okay, special situations. So Kimberly talked about minor children, and even a special situation related to minor children would be a special needs child. So a child that has special needs and probably will not be able to support himself or herself during the course of their lives. And so that's one of those areas where if you're looking at getting an estate plan, you really, really do want to talk to a lawyer and make sure that you're taking advantage of all of the provisions and the government benefits that child may be entitled to after your death. You also want to be looking at life insurance to make sure that that child would be prepared for after your death. And so these are in addition to just the planning for a minor child, we're just highlighting here some other situations where you do really want to be careful and be sure to work with a lawyer. Another special situation is if you are a business owner or a real estate owner. And we at Catalyst really do enjoy working with business owners and owners of real estate, given that if an owner dies, often it has implications for the business, not just for the family of the business owner. And so one of the things that we enjoy doing with folks who own a business or have real estate holdings is to think about what particular planning do we need to do to make sure that when the owner exits, that the business will be able to continue to run. So that's another special situation where you really want to be careful and thoughtful about your estate plan. And then the last situation that we run into where we really appreciate having clients who do sort of thoughtful and careful planning is when you're in a second marriage situation. And as we mentioned earlier, unfortunately, we do have some cases where estate plans are contested and people dispute what your wishes are. And this just unfortunately happens to happen in the situation where there's a second marriage. So unfortunately, we've seen quite a few cases where spouse number 2 and the children of the decedent don't get along, don't agree on what should happen with the assets. And so when we see a couple doing an estate plan, when we have a couple doing an estate plan with us, we like to try to take in extra care and be particularly careful about planning for those situations, to be really clear about what the wishes are and avoid any potential litigation down the road. So that wraps it up for us. We really appreciate you spending your afternoon with us. Molly did put in the chat a link to that temporary guardianship agreement that Kimberly went through. You should be able to get it there. If for some reason that doesn't work, do feel free to email us. You can call the office or get in touch by email. We'll be happy to send you a copy of it for your use and completion. I'm going to go ahead and stop my screen share, and then we'll stay on for a few more minutes. Happy to answer any questions that come into the chat room, but also feel free to go and enjoy the sunshine.
So I just also wanted to add that this webinar doesn't create an attorney-client relationship. We've got to talk about the disclaimers and that we are not providing legal advice in this webinar. So if you do have questions about your own situation, we really highly encourage you to contact us for an initial with an initial phone call. We'll spend about 15 minutes with you with no charge, and then decide whether or not it makes sense for you to move forward and either schedule a Zoom call or come into the office for an appointment to answer your legal questions. And so we will also send along a copy of the document that we talked about today, the temporary guardianship agreement, along with the slides by email to you, and hope that that comes in handy when you're thinking about your estate planning. Okay, thanks so much.
That's a wrap. Thanks, guys. Thanks, everyone.